Dear fans and viewers in front of the screen, good evening to you all. Welcome to the Chinese Building Association of New South Wales Building and Development Seminar. I'm Andy and I'm honored to be your host for today's online event. Chinese Building Association of NSW was established in January 2020. The association is dedicated to empower members, empower the construction industry, and empower the local community. The association aims to create a professional platform for communication to help members grow their business and to help the industry become better. As the only industry body that serves the building and development industry, we have gained around 300 member businesses, including developers, builders, contractors, suppliers, and other professionals. CBA and NSW host a series of member events, including business events such as Industry Conference, Building and Development Seminar, Career Expo, and the Industry Summit. We also host regular social events such as sport and barbecue parties that creates wonderful opportunities for our members to socially interact with each other. If you would like to become a member of the association, please talk to our assistant on WeChat to find out how to join. Our association established a brand new channel that hosts a collection of events called Building and Development Seminar this February. We have successfully hosted several events each month since. The channel invites leading experts, institutions, and professionals in the industry to share the latest information about 4 major topics: development, construction, real estate, and renovation. The purpose of this seminar is to 1. Help the Chinese community increase knowledge in all 4 areas above. 2. Promoting the services of our members to the Chinese community. And 3. To enhance the association's standing in the Chinese community. We welcome members with in-depth expertise in these topics to come and participate. Unfortunately, due to the COVID restrictions, our association had to cancel all of our offline events in order to comply with the government regulations and to protect our members. We have created a new lockdown special collection of online events that help our members to learn more about the construction industry while staying at home. Today, we will bring you the 9th episode of the lockdown special collection, and we invited Mr. Zeman from Zeman & Zeman Solicitors, who I will introduce shortly. Although the lockdown has ended and our government has eased many of the restrictions, it is still important to be careful in public spaces. Once again, on behalf of the association, I would like to remind all of our members, fans, and viewers to stay alert and follow the government regulations in workspaces. We sincerely hope that you will support the association's channel and that it will provide you with practical input and valuable opportunities for further networking and learning. On the top of the screen is the QR code for CBA New South Wales WeChat official account and our WeChat assistant. Please subscribe to our WeChat official account if you haven't. We will also upload recordings of our events on our YouTube channel called Chinese Building Association of NSW. Please search and subscribe to our YouTube channel for all past and future recordings. Next, I would like to thank the companies that contribute to the future of the association. Without your support and trust, the association will not be what it is today, let alone this building and development series. On behalf of all my colleagues in CBA and NSW, I would like to thank all of our NN sponsors. If you want to support our building and development seminar, you can do so by sponsoring our events. If you would like to sponsor one of our events, please contact our assistant for more information. Next, we come to the most important part. Tonight, we are very lucky to be joined by our special guest from Zeman & Zeman Solicitors, Mr. Derek Errol Zeman, Principal of Zeman & Zeman Solicitors. He will be talking about the Building and Construction Industry Security of Payment Act 1999. Zeman & Zeman Solicitors had its origin in Johannesburg, South Africa in 1971. Since then, the firm represented both large and small clients in virtually every legal issues imaginable. The commercial side of Mr. Zeman's practice included property development and dispute resolution that continued in Sydney. Mr. Zeman moved to Australia in 1995 and requalified at Sydney University and the College of Law. He commenced his own boutique law firm in North Sydney and has been located there since 2004. He currently specializes in building and construction dispute, as well as commercial litigation, transactional work, property work, family law, and probate work. He appears regularly in all of the courts and tribunals in New South Wales and is admitted to the High Court of Australia. Mr. Zeman is also a public notary. Today, Mr. Zeman is here to talk about the Building and Construction Industry Security of Payment Act 1999 and explain the importance of the act for both developers and builders. He will be talking about how the act can be used properly to make a huge difference to the business of a builder. Next, I would like to invite Mr. Zeman to take over the screen. Just a friendly reminder to our viewers, if you have any questions, please leave them in the chat room, either to all or to me. I will be collecting them and we will have a Q&A section at the end of the seminar for Derek to go over the questions. Thanks very much for your cooperation. Please welcome Mr. Derek Errol Zeman.
Thank you very much, Andy. Thank you for that introduction.
You may share the screen.
And let's share the screen. Minute. Oh, goodness. Now, Andy, I think I may need your assistance here.
Yeah, that's all right.
Are you able to share it?
You cannot share it now. Do you want me to share it on my end?
Oh, there it is. There it is.
That's all right.
There we go. Okay. Thank you, Andy. Right.
Okay.
There we go. Okay. So once again, thanks for your attendance, everybody. I'm privileged to be able to address you all in a subject that I'm quite deeply involved with on a daily basis. As Andy mentioned, I have been involved in disputes in the building and construction industry for some time. This particular act that I'm going to talk about this evening is really of vital importance to builders and developers. In fact, to anybody involved in the building industry, because it allows an avenue to pursue the recovery of debts for all parties involved in the construction industry in quite an informal and quick way. So it allows for alternatives to people ending up in court in very expensive and confrontational matters. And it is an act that very few people are aware of. A number of lawyers, in fact, most lawyers I have found, are not aware of how it actually works. They know about it because it's been there since 1999, but it has some very interesting and intricate aspects to it that can be of immense assistance to builders, developers, anybody involved in the building industry. I might mention that even people who supply goods in relation to building contracts, people who might supply office furniture, for example, in respect of an office building being built, they are included in the types of people who can have resort to this act. People like architects who give professional advice and professional services can be included. So it therefore it covers really anybody involved with building and construction. I'll just move to the next slide. Oops, what happened there? Okay, you must excuse me, I'm not all that tech savvy.
Try clicking to slide 2 on the left.
On the left?
Yeah, click on slide 2. Yeah.
There we go.
Okay, great.
Okay.
Yeah.
So this is what I've been saying. It's now, Andy, how do I get rid of this part on the left so that I can read the slide? Let's see. Oh, I can minimize that. Ah, good. Okay, so this is what I've been saying. In fact, about 97% of building and construction participants consist of small to medium businesses. And I think that this is really what the Act addresses. As you see on the slide, industry employs about 10% of the Australian workforce. Unfortunately, it makes up for about 20% of all insolvencies, but that, I think, is just a factor of how big our industry actually is. And of course, when we talk about insolvencies, that's something that you all want to stay very clear of, and that is something that you can be helped immensely by this Act. Let me start off by saying this, though. The first thing I tell people who consult with me, and it may sound strange to you, is that people should try to have nothing to do with lawyers. Now, that would sound odd, but it really is true, because the law, although it's complicated and the purpose of the law is to have certainty, it has become so complicated that it has become uncertain, and therefore it is quite expensive. And if you're going to get involved with lawyers, you can be sure that it's going to cost you money, and money that could be spent well elsewhere. So, although it sounds strange me saying this, I usually say to people, try and stay away from lawyers. But the difficulty is that when you need a lawyer, there's nothing you can do about it. You need a lawyer, and obviously you need a good one. You need somebody who knows the law that you are dealing with. And in the case of this Security of Payment Act, you need to get the right person. The obligations on builders, apart from licensing, quality control, and that type of formal obligation, consists of an obligation to perform under a contract, an agreement. So this Act, and this is the first point I think you should make a note of, this Act overrides agreements. Now let's see what our next slide says, because I'd like to stay with the slides. Okay, before we get there, I want to pass on to you some information that I have gathered over many, many years. There is a requirement for builders to have programs, to keep to the programs. Obviously, when they don't keep to the programs, that's when the problems start. But the first tip, the trade secret, is that you keep a daily diary of everything that happens in the workplace. It doesn't matter what language you keep it in, as long as obviously the people reading it can understand it, because it's preferable to get whoever you're dealing with to sign that page of your diary, confirming that they understand what it says and confirming that it actually records what's been happening. I see it all too often that months after the event, facts are raised that were never raised before. There was a matter recently involving the new train line out at Kellyville, where my client was unable to gain access to the tunnels that they were building. Now, it was only because they kept meticulous diary notes of everything that there was sufficient evidence for them to be successful in their claim. There was a diary note of, and you could do it on a page a day basis. That's what I recommend. And you can do it hour by hour, but try to record everything that happens. That's something really important. Now I'll come to this issue that I raised earlier. And this is something for you to take away from this evening. It is very, very important. This act, the Security of Payment Act that we're talking about, overrides your contract. You will have a contract whether you're a developer or a builder or a subcontractor. You will have some type of contract. You may even only have a verbal contract, a verbal agreement, which incidentally, you can make a note of this. Verbal agreements are just as binding. The difficulty, of course, with verbal agreements is that you may well be called upon at some stage to prove the agreement. Not only prove the existence of the agreement, but prove its terms. And when it's oral, in other words, verbal, then you may have difficulty. You will certainly have more difficulty than if it's in writing. And that's the purpose of having it in writing, so that you can refer to it if ever that needs to happen. But the important point here is that this act gives you protection that overrides your contract. So if the contract says that you can only put in a claim for payment every 3 months, the act says differently, and the act is what prevails. So that's really an important issue to remember. Let's just talk about the origins. I've said over here what the origins are. The difficulty was this: small builders were finding that the larger operators, larger builders who were their principals, they were subcontractors to larger builders, and of course the builders were contractors to the principals, the developers. The larger operators were able to take advantage of the smaller ones by withholding payment. And it ended in a position where builders were suffering terribly because they were not getting paid, and they in turn were unable to pay their workers and their subcontractors. And the main reason, that was the main reason for this act being passed. The main purpose of the act is to maintain cash flow. So a contractor can be confident in knowing that he has the protection of an act that allows him to lodge a claim, and in all probability, he will get paid, instead of having to go to court and wait for a court decision. Can take years for that to happen. The courts try to act quickly, but it can take a long time. And of course, the court process is very confrontational, which at this stage, I'd like you to make a note of something else that is very important, particularly in the communities in which you're operating. So please make a note of this, that the use by you of this act is far less confrontational than you going to court. The act is an informal way in which a dispute gets resolved by a person who's not a lawyer. I'm going to come to this in the course of our discussion tonight, but this is the adjudication process that the Act allows for. So it's really important for you to be aware of the availability of a process that is far less confrontational than the court process. As I said, the actions of the bigger players had a rippling effect, and the industry was put into a position where building became a very tenuous operation because people were not getting paid, and that's been different. That's been changed now. So I'm just trying to read what each one says. Let's have a look at this. Okay, I've mentioned this. Instead of having to appear in court, the Act introduced this new system of determination by way of adjudication, and I'll come to that because that's one of the main things that we're going to be talking about this evening. And as I've mentioned, it overrides contractual provisions that are at variance with it. Next one. Okay, so I'm going to explain to you what the Act does and how it should be complied with. Firstly, let's see if my slides take this into account. This next slide talks about the difference between contractual rights and statutory rights. It might be an idea, yes, to look at this now. I spoke earlier about agreements and contracts. Now, you would realize that you go into a shop and buy a pair of shoes. You look at the shoes, you try them on, you like them, you pay the man in the shop and he gives you the shoes. That's a contract. That's a simple contract of purchase and sale. You go and you buy something, you need what we call a meeting of the minds. You need to have the intention to buy the shoes, but everything that you do, most things that you do daily, revolves around some type of rights and obligations relating to contracts. The statutory rights that you have are those rights given by an Act of Parliament. And that is what we're dealing with tonight, a statute. And once again, I say, the Act gives the builder statutory rights to payment, irrespective of what the contract says. Now, Section 3 of the Act, look, I'm not even going to suggest to you that you read the Act because the purpose of the exercise is not to make you into lawyers, but really to give you a broad idea of the protection that the Act provides for you. And as I said earlier, it's a matter of cash flow. You can obtain an interim result without the expense of going to court. And I don't want to jump ahead of myself, but when I talk about an interim result, that is the adjudication process that the Act provides for. Importantly, it does not limit, the Act doesn't limit any other entitlement that you may have under the contract. So if you take action under the Act, it does not stop you taking action also under the contract. Obviously, you cannot claim for payment of the same amount twice, but you can claim on a different basis under the contract for different relief. The next thing is construction work. As I mentioned earlier, it is very, very wide. It involves actual construction, alteration, repair, restoration, maintenance, extension, demolition and dismantling. So all of those things that you might be involved with are covered by the Act. There is coverage also for the supply of related goods and services. And as I said earlier, it includes people like Bunnings. Bunnings will supply cement for a job. If they comply with the Act, and I'm going to come to that shortly, then they have protection under the Act. And professional people, such as architects or quantity surveyors, If they comply with the Act in making their claims, then they get the protection. So the related goods and services is something that goes with the construction work, and it's worth bearing in mind. Now, once again, we talk about Section 7. I'm going to just run through the important sections. And Section 7 provides that the Act applies to any construction contract. So, as I said earlier, it can be written or oral, partly written and partly oral. And even if it's said to be governed by the law of another jurisdiction and not New South Wales, that doesn't apply. If the work is done in New South Wales, that's the Act that applies. At this point, perhaps I should just mention that there is a similar Act in the ACT, in Victoria, and in Queensland, where similar provisions apply, but one must be very careful. I have a number of clients on the borders of the states where we have to be very careful which Act applies. And the Act applies where the work is actually done, the state in which the work is actually done. This Section 7 talks about matters to which the Act does not apply. And I don't think this will ever affect you, but it doesn't apply to contracts of loan, guarantee, or insurance, or, as I said, those outside New South Wales. Progress payments. Okay, so this is now, we're coming to the real basis of the Act. The Act gives you a right to progress payments, irrespective of what the contract says. So, in other words, if the contract says you can only get paid at the end of the contract, then that's not, it is contrary to what the Act says, and the Act prevails. Interesting sections in the Act is what I've highlighted. Section 12 talks about pay when paid. Now, you may have come across instances where you contract with somebody who says, look, I'll pay you when I get paid. As you can imagine, it's a very convenient way of doing business to say to somebody, look, I'm expecting payment, and when I get paid, I'll pay you. Well, that type of provision is completely void under this Act. You cannot have such a provision. And if there's a provision like that in your contract, this Act makes it void. In other words, if you don't come to this Act and use it, well, then you're bound by your contract. But if you make use of this Act, the other party can't be heard to say, no, our contract says that I need only pay you when I'm paid. Section 12A is a new section making provision for retaining retention money in a trust account. Now, most of you, if not all of you, would be familiar with retention money, where the contractor leaves money with the principal. I refer to the principal and the contractor instead of referring to the contractor and the subcontractor, just for convenience. So the principal retains money to pay at the end of the contract for any variations or anything, or defects, particularly. If there are defects in the work, then the retention money is used to pay for those defects. Now, this new section provides for that money having to be kept in a trust account, also something that you probably will not really bother about, but it's good to know. Okay, let's get back to this procedure for recovering payment. The first thing is this, and please make a note of this, because this is what brings you under this Act. It is extremely important. your invoice that you give for the payment to you of work that you've done or services that you've rendered or materials that you've supplied must contain wording to the effect that the claim is made under this act. It is vitally important. If your invoice does not contain that wording, you do not fall under the act. Now, this is the first very, very important point. I can't stress it enough. This is what it's all about. So please write that in big letters wherever you're making your notes. It must say, your invoice must contain this wording, that it's made under the provisions of the Building and Construction Industry Security of Payment Act. That brings you within the scope of the Act. The next thing, let's have a look. Okay, so I have jumped ahead to payment schedules, but let me tell you quickly about payment claims. The payment claim is an invoice. It can be called a payment claim, or it can be called an invoice, but if it contains that wording, and if it complies with the Act, then it is a payment claim under the Act. And in order to comply with the Act, it must be accompanied, it must identify the work. Now, this is very important, but most invoices do this. It must identify the work and the charges for the work or each section of the work. And it must be accompanied by certain documents that are set out in the Act, such as a statement that your subcontractors have been paid. Now, this is important because the Act wants to ensure that everybody who is entitled to payment gets payment. And the payment claim is therefore not valid unless it is accompanied by that by those documents that support it. Now, the payment claim gives a certain number of days within which it must be met. And there are a number of things can happen. Either you can be paid the amount of the claim, or you can be paid a part of that amount, or you can be paid nothing. But the party who gets the payment claim, once the claim is made under the Act, must serve on the other party a payment schedule. And that must be done within 10 business days of the payment claim, as you see in this slide. The important thing to remember here is this, and please once again make a note of this. There are time periods in the Act, and we can talk about the actual time periods in the question and answer section. But what the important takeaway point for you this evening is that these time periods are not negotiable. They can't be extended, and if you're out of time, you're out of time. So if you don't do something within the period of time that is allocated, you don't get the protection of the Act. So it's really important that you know what these time periods are and you comply with them, because there's no mechanism to extend them. So now, having served on the other party a payment claim, the other party must serve on you a payment schedule. The payment schedule must also comply with the Act, and it must schedule what it is, the amount that you're being paid on your payment claim. And if it's less than the amount claimed, it must stipulate what the amount is and why it's less. And that must all be done within this 10 business days. By the way, incidentally, the days reckoned in the Act are all business days, so they exclude weekends and public holidays. So now the next one is going to go on to the consequences of not paying where there's no payment claim. So the picture that I'm going to give you is this. You serve a payment claim on your principal. You want payment of a certain amount for work that you've done. Your claim is supported by the documents. It has the statement confirming that you've paid your subcontractors, and your principal does nothing. He just keeps quiet. He doesn't pay you. He does nothing. The Act allows you to start proceedings in court for what we call a statutory debt. What this means is this: if you start proceedings in court, you will not have to prove in those proceedings that you did the work. All you will have to prove is that you served a payment claim. And once you have served the payment claim and there has been no payment schedule, your debt becomes a statutory debt that is payable by the principal. If you get a payment schedule, which admits an amount, that amount also becomes a statutory debt. So if an amount is admitted by the person to whom the claim is made, then that amount can be sued for as a statutory debt. I'm jumping ahead to the adjudication now of disputes, but I think it's important that I point out to you other possibilities. If a payment schedule is served on you, but it does not allow for any payment, you have a couple of options. The first option, as I said, is to sue in court. And if you choose to do that, all you will be required to demonstrate, to prove to the court, is that you served a payment claim. But the other option is to go to adjudication. And this is the second major takeaway point for this evening. Adjudication is something that is constructed by this Act for the case where there are disputes, and if a payment schedule is either not given at all or given for an amount less than your claim, you then have excuse me, you then have the right to apply for adjudication. Now, adjudication involves going to a statutory body who are appointed, and they appoint an adjudicator. An adjudicator is not a lawyer, so you're not going to be faced with legal technicalities and legal complications. The adjudicator has certain time limits to make a decision, and his decision, which he hands down, if it's not paid by the respondent, the person you're claiming from, within a certain period of time, you can take that decision to the court and you can lodge that written adjudication determination as a judgment. Please make a note of this, that it becomes a judgment of the court and it cannot be argued without money being paid into court. So in other words, the respondent can't come along and say, no, there was a mistake and I want the case heard, because as I mentioned earlier, this adjudication process is an interim process. The purpose of it is to give you interim relief by the payment of the amount of your claim, but it doesn't stop the person against whom the claim was made from going into the main case in court. So in other words, if you put in a claim for a month's worth of work and there's no payment schedule served on you, the person against whom you claimed must pay and can go to the court saying the job was defectively done. But in order for him to raise that, he's got to pay the amount of your claim into the court. I was talking about time periods. So here I've given you details of some of the time periods in the adjudication process. There is the adjudication application which you would make, and then there is the adjudication response that the respondent is obliged to give within a certain number of days, and the adjudicator then looks at the application and the response and he makes a decision. Now, I would like to just point out that the adjudication application ought to be done by somebody with a lot of knowledge of the job, of what went wrong, obviously by reference to that diary that I spoke about in the beginning. But there is quite a lot of detailed work that is required in quite a short period of time for the adjudication application. And similarly, the adjudication response is something that's very important, because once the adjudication is made, the person who gave the response is stopped from raising anything that was not raised in the response. Look, I don't want to go into too much technical detail here, because this is all really legal stuff that I'm talking about. But it's good to know what the protection is that you have under the Act because of the strict time limits, because of the informality of the adjudication process, and generally the purpose being to keep your cash flow going. The Section 25 is the filing of the adjudication certificate. That's what I've spoken about already. It gets filed as a judgment. So as you would know, there is, once it's a judgment, that's the end of the story. There's no more argument about it. And that would bring that part of your case to an end. And if the principal wanted to go into the main case with you, he would have to either pay you or pay the money into court. Now, there are other rights that have introduced in a recent amendment to this Act, and they provide for a contractor to seek payment of claims under a subcontract directly from the principal. So I'm not going to take much time with this, because I know that you're going to have questions, but just remember that you, as a subcontractor, if you're not paid by your contractor, you can go to his principal to look for payment. As I mentioned earlier, other rights are not affected by the Act. This is the slide that we're on now. There are other acts, by the way, that you may have resort to. There is an act called the Contractors Debts Act. You can make a note of that also. The Contractors Debts Act allows you also remedies against a principal. Now, Section 34, that's what I said in the beginning. This Act has effect despite any provisions to the contrary in any contract. And that's it. It's now 7:45, and please ask me whatever questions you may have.
Thank you very much, Derek. Yeah, and I have some questions here. So the first question is, does this Act apply to all building work?
The short answer is yes, save for that work involved with loan agreements or guarantee agreements and certain residential work. There certain residential work is excluded from the Act. And that we can have a seminar at some other time about the Home Builders Act and how that ought to be complied with. But to answer your question, certain residential building work is excluded, yes.
Yeah, thank you very much, Derek. Just a friendly reminder, if anyone who else have the questions, please leave them in the chat room. I'm still collecting them. Okay, and next question is, how do variations affect the agreement?
Okay, that's a good question. In most building contracts, disputes arise because of variations. Variations can take many forms. Usually they are as a result of delays, but also obviously a person can ask for an alteration to the work being done, and that's a variation. And the short answer is that under the Act, as long as whatever you did as a builder went into your payment claim, including variations, you are covered by the Act. So the Act covers all issues in a claim, including variations and delays.
Thank you very much, Derek. And next question is, how do time delays affect the agreement?
Okay, well, once again, if there is work done, additional work done because of delays or additional expenses incurred because of delays, then it would form part of the claim and you would be covered for that. There are a number of contracts that provide for delays, and some of them say that the principal will not be liable for certain types of delays. Now, that is not recognized by the Act. The Act says that whatever you do, you're entitled to be paid for, which brings me to a very commonly used term, and that is what we call liquidated damages. Most builders will be familiar, well, they will have heard the term, they may not be familiar with what it actually means. Liquidated damages are what a person can claim without having to prove how the damages were calculated. So in other words, if there is a delay not occasioned by the builder can insert a clause into the contract that he is entitled to liquidated damages at a certain number of dollars per day. The principal can do the same. The principal can say to the builder, look, if you don't build on time, I'm going to claim liquidated damages from you at a certain number of dollars per day. The liquidated damages, that term simply describes damages that the party does not have to prove. So in other words, the party who alleges that he suffered the damages doesn't have to come along and show what his turnover is and what staff he had to pay and what his expenses were for the delay period. It's an agreed amount. and liquidated damages, to answer the question, and this is the important thing, that liquidated damages are claimable in your payment claim.
Thank you very much. And next question is, must the contract be in writing?
Well, that's also a good question, and it's particularly answered in the Act, and the short answer is no. It does not have to be in writing, but as you can imagine, and as I said in some of my opening statements, it's far easier to prove something that's in writing than to try to prove something that is oral, because you know what we say. We say that there's your version and my version and the truth. So there are always three versions to everything. So when you don't have something in writing, then you are faced with a potential problem. But to answer the question, the contract does not have to be in writing.
Thank you very much. And next question is, what type of laws cover the building industry?
Well, that's good. That's a good one. You know, as with everything, the law has become complicated. As progress is made, it gets more complicated. People ask more questions. People do things that the law didn't anticipate. So it's constantly evolving and it is constantly expanding. Just off the top of my head, there's obviously the Home Building Act that a lot of your members may be involved with and may be familiar with. It is worth knowing what it's all about. And as I said, it may be worth having another seminar just for that act, because there are a lot of technicalities in that act that ought to be complied with. So that's the Home Building Act. There's the Contractors Debts Act that I mentioned. There's general contractual law. Involving builders directly, that would really be it. But, you know, of course, there's all the licensing that you have to go through, the occupational health and safety issues that a builder has to go through. There are a lot of technical things that a builder must know, and that's why they are doing your course, because that's what you're going to teach them. But from a legal point of view, those are the main statutory laws that govern the building industry.
Okay, thank you very much. And next question is, should I form a company for a business?
Well, that's also a good question. You know, the origin of the formation of companies, it's an English concept in English law. And the purpose was to separate the directors and the shareholders from the company. You know, in our law, we have natural people who have the capacity to enter into a contract, and we have legal people, juristic, what we call people, who also have that capacity. And there are only those two classes of people. So the one is a natural person and the other one is a person created under what we call the Corporations Act. And obviously there are other types of corporations, but the main one is a private limited company. Now, in the old days, a director could do things and not attract personal liability because the work was done in the name of the company. What has happened is, as company law has developed, so the obligations of the directors have become more stringent and more onerous. And it is therefore a good idea to consider very carefully whether you want to operate in the name of a company. A company enjoys a lower tax rate, as your members would probably be aware, and you can write off assets in a company, and you can distribute profits in a company. So there is a lot to be said for operating a business through a company, but there are also a lot of obligations. So those factors must all be weighed up. The alternative, of course, is that you have a sole trader that he operates in his own name. The issues that will be faced by your members are things like, sorry, I didn't realize that my screen was so down. The issues that will be faced by your members are things like tax and how profits are distributed and the day-to-day operating of a company. So there's no clear answer to it. It's something that that one really should talk to professionals about. There are pros and cons for operating both ways, through a company or in your private capacity.
Yeah, thank you very much. And just before I ask the last question, and just letting everyone know that I have just put on Derek's contact information up on the screen. So as he have said before, hopefully everyone doesn't need a lawyer, but if you want to find a lawyer, then you need the best in the industry. And so feel free to contact Derek if you have any more specific questions, because this is a very complicated topic. And so if you want to know more information in how the law can be applied to your situation, then feel free to contact Derek. And the last question that we have today is, how does a partnership work?
Okay, so a partnership, one has to be quite careful of, because the general rule is that partners bind each other's credit. So when you go into partnership with somebody, that person can get you into trouble in spending money that you may become liable for. But there are a number of different types of partnerships. We have an act, a statute called the Partnership Act, that deals with limited partnerships and registered partnerships. So there are all sorts of different types of partnerships. But basically, a partnership is a good thing when each partner can bring something to the table. So you may have a person who is particularly skilled in one avenue. You may have a person with no skills but a lot of money. You may have a person who is a good organizer, a good administrator. Those three people going into partnership, that should be a workable partnership. But the thing to watch always is this overriding danger that partners can get their partners involved in debt. That is something that can be dangerous. So once again, you need good advice on that.
Yeah, thank you very much. And that's all the questions for tonight. Thank you very much, Derek, for sharing such great content with us. And thank you to all of our viewers for joining the new installment of Building and Development Seminar. If you would like to be more involved in our events, please subscribe to our WeChat official account. Don't forget, all of the recordings for our event will be on our YouTube channel. Search Chinese Building Association of NSW and subscribe. You can find all of our past recording there. Thank you for supporting the Building and Development Seminar. And that concludes our program for today. See you next time.
Thank you, Andy.
Thank you, Derek. Okay, bye.
Bye.